to your application.
Lordship, please.
What you say in para 10 is that it is submitted that donor details were kept. I'm sorry, just give me a moment. You have it? That's the application. The MA.
IA 57604.
It is submitted that donor details.
Yes, my lord.
Just one. It is submitted that donor details were kept in a sealed cover at the designated branch, and all such sealed covers were deposited in the main branch of the applicant bank, which is located in Mumbai.
Yes, my lord.
On the other end, each political party was required to maintain a designated account in any of the 29 authorized branches. It was only in this account that electoral bonds received by that party could be deposited and redeemed. At the time of redemption, the original bond, the pay-in slip, would be stored in a sealed cover and sent to the SBI Mumbai main branch. So what you are saying is that donor details were all sent to the SBI main branch. Redemption details were all sent to the Mumbai, the same branch, the SBI Central Main Branch in Mumbai.
Yes.
Now 12. It can thus be noted that both sets of information were being stored independently of each other. Thus, to rematch them would be a task requiring significant amount of effort. In order to make available donor information, the date of issue of each bond will have to be checked and matched against the date of purchase by a particular donor. This exercise would only deal with the first silo of information. These bonds were redeemed by political parties in their designated bank accounts. Accordingly, this information would then have to be matched against the bond redemption information that makes up the second silo. It is submitted that the retrieval of information from each silo and the procedure of matching the information of one silo to the other would be a time-consuming exercise. The details are stored separately. Some of the details, such as bonds number, are stored digitally, while the other sets of details, such as name of purchaser, KYC, are stored physically. The purpose of not storing all details digitally was to ensure that it cannot be gathered easily to achieve the object of the scheme. And then finally, para 14. In that regard, it is further submitted that this court has directed for making public the donor information to the date of its interim order, 12th April 19, to the date of the judgment. In that time, 22,217 electoral bonds were used for making donations to various political parties. Redeemed bonds were deposited to Mumbai main branch by the authorized branches at the end of each phase in sealed envelopes. Coupled with the fact that two different information silos existed, this would mean that a total of 44,434 information set would have to be decoded, compiled, and compared. Now, if you see the directions which we have issued at page 76,
my lord,
we have not told you to do the matching exercise. We have asked you for a plain disclosure. Therefore, the ground on which you seek an extension of time to make the disclosure does not accord with the directions in the judgment at all. The judgment doesn't tell you to do that.
No, my lord, I'll tell my lord what we understand. If that is not so, then of course there is no problem. If your lordship is pleased to turn to para 221.
But then you simply comply with the judgment.
No, please turn to para 221. Your lordship's judgment?
Page 76, right?
76, yes. SBI shall submit details of electoral bonds purchased since the interim order of the court. Well, no problem. No problem. The details shall include the date of purchase of each electoral bond, the name of the purchaser of the bond, and the denomination of the electoral bond purchase. Now, my lord, when the purchases were happening, we divided the information. The name is kept at one place and the purchase is recorded at another place.
But ultimately, everything was sent to the Mumbai Central Main Branch. All issuing branches, for the political parties, there are only 24. Actually, there are 4. But insofar as the purchasers are concerned, everything has been remitted back to the Mumbai Central Main Branch.
Except, I'm sorry, my lord, your lordship is right. It is not kept at one place because the reason, if your lordship just see then earlier para, my lord was pleased to see para 10. If your lordship just sees para 5 and 7, that's why the problem has arisen in this case. Para 5 said central government framed the electoral bond scheme, which provided that the information furnished by the buyer shall be treated as confidential and the bank shall not and shall not be disclosed by any authority for any purpose. Now, my lord, we knew this is sensitive information, so a physical procedure was devised. You sort of did a KYC and you kept the name in that. And once that was cleared, then only the bond number was cleared, and then the bond number was used for further purchases. The money came to people who didn't know who the money was, who was the real name of the purchaser. They just knew this was a cleared account, so it came into a bond payment account, and from the bond payment account it was given. And it was done precisely, Manoj, to prevent this kind of gossip coming out saying so and so has purchased so much. Now, Manoj, para 7, if you see the SOP, because this is not something we've done now, Manoj, this is the original SOP, said no details.
Ultimately, even your FAQs, which were shown to us during the course of the hearing,
Yes.
the FAQs indicate that for every purchase, you have to have a separate KYC.
Yes, we have that. We have that.
Therefore, it's very clear that every time somebody made a purchase, a KYC was mandated. That one set of documents, namely the electoral bond application form, KYC documents, citizenship documents, and pay-in slips.
Manoj, there's no issue. We have the details. Please don't
particular-
misunderstand me.
Therefore, you have the details.
No, I have the details. I'm sorry. I'm not saying it's not there.
One minute, Mrs. Salve. Now, paragraph 10, you specifically say that all the purchasers' details have been kept in a sealed cover.
Yes.
In the main branch of the applicant bank.
Correct, Manoj.
Just have to simply open up the sealed cover and
Manoj,
collate the names and give the details.
Manoj,
As far
what
as
is...
paragraph 11 is concerned, you're saying that the Dhoni's details are being kept in a sealed cover, envelope in a sealed cover. Open up the sealed cover and give the details. In fact,
Tell Manoj where the only bit of information...
if I'm not mistaken, the EC was asked to file an affidavit, which you in a sealed affidavit or details in a sealed envelope, which we have not opened. With regard to the donor details and other details during the course of hearing, which they may have filed.
Manoj, my problem is this, Manoj. With respect, in fact, just responding to what my lord has said, I have full details of who purchased the bond, but that's put in one silo of information. I have full details of where the money came from, which is in a second silo. And I have a complete detail of which political party tendered how many bonds and who has been paid how much. That's a easy ask. That can be given straight away. The problem is, Manoj, I have to now put the name of the purchaser, which is in the first sealed packet. And these are all physically kept. They were not put into the banking system. Each form will have to be taken out, the name checked, that name now correlated to the payment detail, and the payment detail correlated to the bond, and finally that's where the bond number gets generated, and then we can connect as to which political party who has given that money.
Now, that's not been asked, Mr. Sarve.
But Manoj, I have to give
direction to correlate it with the purchaser and the political party.
Manoj, para 76 does suggest that. Would your lordship just see it for a moment? If you
don't go by what is suggested. Whatever you wanted to speak, just spoken in black and white.
No, in that, Manoj, your lordships, please see that sentence. I'm not, Manoj, we have no desire at all to try and expand our own job, Manoj. Please see page 76. This by itself is creating difficulties. Manoj, your lordship say the details shall include date of purchase of a bond, no problem. But the moment I have to give the detail of the name with the bond number, that is taking time because we had deliberately put these in two silos. If your lordships want only the details of who purchased the bonds, we can give that straight away.
Mr. Sarve, our judgment is dated 15th of February 2024.
Yes, ma'am.
We are now on the 11th of March.
Yes.
In the last 26 days, what extent of matching has been done by you? What steps have you taken in the last 26 days? The application is absolutely silent on that.
We can put a detailed affidavit on that one because I know
it should have been disclosed in the affidavit.
I agree, man. I agree.
State Bank of India, which is coming to us, we expect that there should be a degree of candor on the part of the State Bank of India. That this is what the work which we have done. The work is at this stage. We need an extension of time to carry out the balance of the exercise which remains.
Lord, we have sought to explain the problem and the work is going on. Because, my lord, each form, it'll have to be form by form.
What is going on? To what extent you have reached?
My lord, work is going on form by form. They will, if you're not on, I can give the exact detail of how many we have covered and how many more we can cover. But they did a rough calculation, my lord, it will take about 3 months more. Because I'll tell my lord, my other concern. I have another big concern, my lord. I cannot make a mistake in this. I'll get sued by the donor. I'll get sued by people because I cannot by mistake say A got it when B had it.
Highest court of this country. So where is the question of you being sued?
I'm sorry, my lord.
Whatever you are doing under the directions of the highest court of.
No, my lord. If I make a mistake, if I say Mr. X got it instead of Mr. Y got it in a hurry to give the numbers, I could create havoc there, my lord, because ultimately.
As we take it, Mr. Salvi, you are accepting that there's no difficulty in giving names of the donors who purchased the bonds and the amount they purchased the bonds. You have got no difficulty in giving details of the political parties who have purchased the particular bonds. The only difficulty is matching the purchased bond with that. But 26 days, you must have carried out at least some, say, 10,000 bonds you have been able to collate, 5,000 bonds you have been able to collate.
Quite frankly, what I saw, they were struggling with it. They were making charts which we saw were not matching. They don't. I'll tell you what has happened. No, I'll tell you candidly what has happened.
If I'm not mistaken, it was pointed out to us that the bonds had some number which under some instrument they were able to.
Yes. But that number.
That's all has to be done.
That number is not to be found in the application for purchase or in the first set of documents. The problem is that number, when number was generated, that number has been scrambled and put elsewhere, and that number has been kept secret. Now, putting that will require tracing it into each transaction. At the stage of the interim order, and I'm saying what happened at that time. The kind of information which your lordship asked was a macro information. So that is no problem.
In pursuance of the interim order,
yes,
Election Commission of India has filed, details before us.
Or whatever they have.
In separate silos, if we can use that expression.
Yes.
The ministry has placed that, in secured custody with us. We'll direct them to open it here right now, because since we were deciding a point of constitutional validity, we didn't consider it necessary either during the course of the hearing or thereafter. So we can ask them to open it, and we'll ask the Election Commission of India to divulge whatever there is, and we'll ask SBI to then divulge what we have asked them to do.
Yes, we'll do it. We'll send it to
before us.
Your lordship.
Mr. Sharma, whatever has been placed by you before us, in compliance with the judgment, we will direct that to be open right now.
And your lordship directed us to give it to the ECI. So we'll give it to the ECI, or your lordship want us to file it directly in court? I think better through the ECI.
No, you, Mr. Salve, you comply with the order of the court.
To give it to the ECI.
Whatever ECI has placed in the court.
Already.
We will direct that to be open. We'll ask our court to make a copy of it, a digitized copy for the safekeeping of the court. And then we will return it back to the rest. We'll return it back to ECI for them to upload it on their website.
What ECI has already, there's no problem. We will give to the ECI as in the time, if you're not to give us 3 months, we'll go and give it to the ECI. And they, as and when they get it, they can upload it. We want to make sure we get every bond number right, every donor right. Because this otherwise is going to create havoc. For today, for donors who come and say, this is not my bond, I did not purchase this, you put the wrong number on my bond, I did not give
to. There's no question of that. Once he's given the KYC, he's given the details, you also have the application. The application will be having the amount.
No, I'm sorry, Marat. I'm sorry. My concern is he purchased bond number X. I by mistake, I put his number as purchasing bond number Y. Now, X may have gone to political party A, Y may have gone to political party B.
Why will that happen, Mr. Sir?
Because I'll tell Marat why. Because they haven't kept
number one bank in the country. We expect them to be able to handle this.
No, not expect to be handled. We were told make sure that this doesn't leak. So Marat, the way we stored the information, the bond number did not get into the core banking system. If we had been told keep information on this basis, we would have devised our systems accordingly. If we had kept it like that, Marat, any senior bank officer could have found out bond numbers and the whole thing would have been out in public domain. who has how much, all these secrecies.
An Assistant General Manager files an affidavit in support of the application to the Supreme Court for modification and order of a constitution bench. It's a very serious matter when you ask for modification of an order.
I accept that. I accept that.
An
I
Assistant
accept that.
General
And we
Manager
have,
files an affidavit and tells us that, look, I'm finding it difficult. The information is maintained in two silos.
no, but he has filed the affidavit because he's the man in the spot. He's the person who has to do this job. He's the level at which these accounts are kept. He said you must have the person who knows what he's talking about. So, Malad, give us a little time, we'll do it. Ask for time.
While your lordship is doing that, let me just show one or two things from.
Let's.
Not mistaken, earlier also you had given one envelope. At the time when the interim order was passed.
Malad, so I'm sorry, Malad. So that nothing is lost in translation.
Then we'll follow that.
Malad, I'm sorry, Malad. I just wanted one clarification as we understand. Well, I was saying something.
Yes, Mr. Alden.
But if your lordship there may be a way out around this. But if your lordship turns to your lordship's order, para 221, page 76.
Yes.
There are two parts, B and C. If you don't have to create a bridge between the two, then within 3 weeks we can give everything.
So we'll dictate an order. We'll dictate
May I,
an order
Manoj,
because
I'm
let
sorry,
us do it in the court itself instead of.
I wanted to just
telling it.
make one respectful suggestion. Manoj.
Yes.
If your lordship sees para 221,
Yes.
Malad, if B and C are not to be matched, then Malad, we can give the information in 3 weeks. Let me explain how. If we, on one hand, is the person who purchased the electoral bond and the number of bonds he purchased, that Malad, in 2-3 weeks, we can get all the figures. In the second, the bonds encashed by political parties, which includes the date of encashment and denomination. That details we have, Malad, that we can give. In 3 weeks, we'll put it all together.
You
If we
require
have to,
3 weeks for what, Mr. Sarvi?
Malad, these are all in because the accounts are separate, the payment has come separately and the name was kept separately. We'll marry the two and give it.
The political parties have already given the details of the encashments made by them.
Correct, Manoj. So that in any case is there. As far as B is concerned, we can give it.
Details also are already available with you.
I'm sorry, Manoj.
You're working on with regard to the purchasers, donors, and the details of amount they have purchased. These details are already available.
Yes, so that we can give, Manoj. We'll just put that figures together and give. The trouble is, Manoj, we understood B and C meant that we had to give a complete correlation of who bought how much was received, how much was given to whom, and with which bank, or rather which party encashed it from which bank. That bridge was creating that difficulty, Manoj. If you don't have to give that matching.
Right. What we'll do is we'll dictate an order.
Yes.
Before your lordship.
After we dictate it, if there's something which remains, you can tell us. By a judgment dated 15th February. 15th February. By a judgment dated 15 February 2024, this court declared the electoral bond scheme and the provisions of the Finance Act 2017, which amended the provisions of the Representation of the People Act 1951 and the Income Tax Act 1961 unconstitutional on the ground that the non-disclosure of information regarding the funding of political parties is violative of the right to information of citizens under Article 19, bracket 1, bracket A of the Constitution. Full stop. The amendments which were introduced by the Finance Act 2017 to the provisions of the Companies Act 2013, permitting unlimited funding of political parties by corporate entities were held to be arbitrary and violative of Article 14 of the Constitution. Full stop. Next para. In order to give full effect to the judgment which was rendered by the Constitution bench, this court directed the State Bank of India, footnote SBI, which was the authorized bank to deal with electoral bonds under the electoral bond scheme, to submit details of the electoral bonds purchased by the contributors and redeemed by political parties between 12 April 2019, into brackets, the date on which an interim order was passed by this court directing the Election Commission of India, footnote ECI, to collect details of the contributions, bracket, till 15 February 2024, bracket, the date of the judgment, full stop. This court directed SBI to submit the following details by 6 March 2024 to the ECI. A, details of each electoral bond purchased, including the date of purchase, the name of the purchaser, and the denomination of the electoral